In the courtroom, we have rules. I don't always like the rules, but we have rules, and we have a judge. And the judge keeps order in the courtroom and makes rulings based on evidence. And there's certain things that the jury can hear, and unfortunately, there's certain things that the jury is not allowed to hear. And the judge makes those rulings for us. And one of the most important rulings that the judge gives to the jury, actually, and to the lawyers, but more to the jury, is stay off social media during this trial. Do not do experiments in this trial. Don't look up the lawyers, don't look up the judge, don't look up the case, and don't talk about it. And there's reasons for those rules, and it's vitally important that jurors follow those reasons. Now, I don't come from the social media background at all. It seems like the younger folks are more interested in Facebook and Twitter and Instagram and who knows how many other ones that there are. But I'm not as familiar with social media as some of the younger folks that I know. But this day and age, the younger generation is very in tune with Facebook in particular, but also Instagram and Twitter, MySpace, and others. And if you're talking about the case on any of those social media sites, it's against the rules of the court, and it's going to cause a mistrial. So it's vitally important for jurors to listen to the judge when the judge gives an instruction to the jury to follow the rules and to stay off social media. Jurors are supposed to keep an open mind throughout the case and not formulate opinions until the evidence is concluded. And there's a reason for that. The judge is trying to create an even playing field for both the plaintiff and the defendant. And that's the spirit of why we have these rules. And if we have jurors that are going on social media and telling their friends and their family about the case, how they feel about the case, twittering about the case, that is devastating to the outcome of the case, because ultimately what that's going to cause is a mistrial in the case, which is just extremely frustrating for the judge and just horrible for both the plaintiff and the defense, because you have to start all over from the beginning. So the judge, in trying to balance the case and balance the interests of both parties, the plaintiff and the defendant, there are rules of evidence, and the judge makes decisions on what the jury will actually hear in the case. And there's reasons for that. And a juror may have a burning desire to know something or feel the need to conduct an experiment to prove something to themselves. And while I understand that they may feel that need, they can't do that. And there's reasons why they can't do that. And one of the ways they can try to satisfy their burning desire of knowledge is they can raise their hand and ask questions. We now in Florida allow jurors to ask questions. And I encourage jurors to ask questions, because we don't want jurors to have questions in their mind that aren't answered. And the defense probably doesn't either. And sometimes lawyers don't answer all the jurors' questions because we can't anticipate what every human being would want to know. And many times, they're great questions that we can answer. But they should ask them, because if we can answer them, we will. And if we can't, there's a reason. We have rules of evidence, and if the judge says the question can't be answered, it can't be answered, and the inquiry stops there. You are not to go outside the courtroom, either physically or on social media or on the web, and conduct your own research.